control and is in fact usually the settlor, is even a trust at all. But at the very least, it's got title problems, it's got indemnification problems for the parties that are agreeing to defend the trustee, etc. And it may have an even greater problem if a court decides to interpret that right that the buyer has as a purchase of the property that they intend to live in. If you're dealing in states like Alabama, Florida, Georgia, Hawaii, Indiana, North Dakota, Ohio, and Illinois, it should be in there somewhere. The original land trust originated in Illinois. There's privacy, there's asset protection by discouraging lawsuits because people don't see that you own the property. But guess what? If there's a problem on the property, they're going to sue whoever the owner is, and the owner is the trustee. And you've got to defend the trustee. So it doesn't make a heck of a lot of sense to me when you can create a simple LLC and remove yourself from the liability of the ownership. It does have some benefits, but it also has some real problems. And I've included those. By the way, generally, if the beneficiary has all the control and the trustee is just a nominal trustee, the tax benefits or the tax consequences are put on, the federal income tax consequences are put on the true party that controls the transaction, which in this case is the beneficiary. So you can argue that that can work to your benefit if you're using a land trust. There's the confidentiality provision. Since the agreement is not recorded, and it typically has a provision that the trustee is not to disclose the terms of the trust agreement, but if he gets sued, he'll be subject to a court order where he'll be required to disclose it. So anyway, we've got these problems. I've raised them very quickly. In theory, by the way, just so you'll know part of the game, the due on sale clause used to be enforced by the 50 different states in 50 different ways. And the federal government came along and decided in 1982 that they were going to pass a single statute that would decide how all of these various state statutes should be enforced. And it was called the Garn-St-Germain Depository Institutions Act. And that statute basically says that you can't, and by the way, you can always, every lender can always enforce a due on sale clause in a commercial transaction, according to Garn-St-Germain. But in residential transactions, lenders have limits on their ability to call a note due simply because the title of the property is transferred without the lender's consent. And they're in the situation where the borrower dies. Make sense? Okay, the Congress has decided that it wouldn't be fair to call a note due on the heirs of somebody who's dead. Okay, if the payments are continue to be made, they're not going to allow the lender to call the note due. Or there's a divorce and there's a transfer between spouses. And they're not allowed to call it due for a lease, as long as that lease is less than 3 years and doesn't include an option to purchase. So if you enter into any kind of a lease with an option to purchase, the lender has the right to call the note due. And then the reason that people got all excited about the use of a land trust as a way to get around the due on sale clause was this exception in the Garn-St-Germain Act, a transfer into a living trust. But that's where most of the people who are advocates of the land trust stop. They don't want to read the next part. The next part says, in which the borrower is and remains a beneficiary and does not relate to a transfer of rights of property, of occupancy in the property. So if you're going to transfer your beneficial interest and you're going to give the new buyer occupancy of the property, at least Garn-St-Germain appears to give the lender a continuing right to call the note due. So legally, you're not going to get around that provision. Now, by the way, it's really important to say before I run out of time, there's no due on sale jail. If you transfer the property to somebody and you don't get the lender's consent, that doesn't mean you violated the law. That doesn't mean you've committed a crime. There's no due on sale jail. What you've done is to create a situation in which your lender has the right to call your note due. Now, you think that happens very much in the current environment? Almost never. If there's a seller who's taken a note back and they want their cash and they're looking for any excuse imaginable, if they see the transfer of the property and they don't get their consent, they may call the note due. But institutional lenders, don't you think they got enough foreclosed properties in their inventory already? And if the loan is otherwise performing, do they really want to call a note due that's earning 6% in a rate environment where they would have to take that same money and loan it out at 4%? Not very likely. Does that make sense? Okay, so because there's no due on sale jail, there are all kinds of strategies that involve taking the risk that the lender might call the note due. You just need to disclose that risk. So you can carry back, anybody see what time it is? I can't see.
About 20 after almost.
Okay, I got about 10 minutes, and I'm going to run out of time to get to all this. Here are the regulations for the due on sale clause enforcement through a transfer into a living trust in which the borrower is and remains the beneficiary and occupant of the property. The lender also has the right to require you to give them notice of any subsequent transfer of the beneficial interest. So you can make a pretty good argument that Garn St. Germain doesn't bless using a land trust to get around the due on sale clause. It just does a better job of hiding it, right? Okay, just kind of like a lease coupled with an option. You think there are many lenders out there that call a lease of more than 3 years, that when they find out there's a lease of more than 3 years, you think they call that note due? Almost never. Do they have a legal right to? Absolutely. Okay, and most due on sale clauses say specifically we have the right to call the note due if there's a lease coupled with an option or if there's a lease more than 3 years. So there's no magic to or true protection of the assets in the hand of the trustee if you're using a land trust. There are some benefits, and I talk about those, but there are title problems, etc. And most lawyers don't use them. Most lawyers are not going to bless your transaction using land trusts because of the uncertainty. It's sort of like location, location, location. It's uncertainty, uncertainty, uncertainty. Now, by the way, in addition to Texas statutes, the Texas State Bar always has a committee during the legislative session, and it's the Real Estate Legislative Affairs Committee of the Real Estate Probate and Trust Law section of the State Bar of Texas. If you put that into Google, you're going to bring up the most recent report. Sometimes there are as many as 1,200 statutes that are condensed and reviewed or described that were passed in this legislative session that affect real estate. Fortunately, they're organized by foreclosure statutes or landlord-tenant statutes or anything from fire, smoke alarms and things of that nature. You can go find them. But it's a powerful source of information. Sometimes I think it's more important to tell you how to fish than to give you a fish because the rules are constantly changing. Very quickly, because I'm running out of time, there is a statute that says if you're going to leave in place an existing loan when you sell a property to a residential buyer, then you've got to give a notice not only to the buyer but to the lender. And this is the statute that talks about that. And so you have to have these magic words, and part of the reason I give you the PowerPoint is so that you can go and see these things yourself without me having to take the time. But failure to provide this notice doesn't void a conveyance, but the buyer can terminate the contract after getting the notice. So the key exception, the key exemption to this statute is when you sell a piece of property to a residential buyer, if you get title insurance, statute doesn't apply. Now what should that tell you? That tells you the title insurance lobby is better than the real estate investors lobby, right? Okay, I'm going to stop and take questions for whatever time we've got left, and I know there's another speaker coming up. Questions? Yes, sir.
So you take over a note subject to get title insurance and debt?
Well, now you're talking about a different situation. You're going to buy a piece of property subject to an existing loan because you're an investor and you're not residential owner-occupant of that property. Statute doesn't apply. But my strong advice to my investor clients is never buy a piece of property simply by getting a deed from the seller subject to the existing debt. And the reason is, now the title's in your name, but you're not obligated on the debt. The seller's still obligated on the debt, but he doesn't have a remedy. If you don't pay his loan, he has no remedy whatsoever. And as a result of not having a remedy, If you don't pay his loan and he decides he's going to get mad and he goes to see a lawyer, don't be surprised if the lawyer that he sees isn't a real estate lawyer, he's a litigator. And he's going to say, how is this possible? You don't own the property, but you owe the debt. He doesn't owe the debt, and he owns the property. He must have defrauded you. And if you've had an ad that says, we take over payments or anything to that effect, it sounds like a promise that you've made to make his payments. And I've had client after client get sued because they bought a property subject to the debt. Now, there's another way to handle it. Give the seller a remedy. Give him a wraparound note. Give him a deed of trust so that if you don't pay his debt, he has a remedy. Now, his remedy is limited. His only remedy is to be able to foreclose. And be smart. Buy the property in a separate legal entity, so if there's a foreclosure that takes place, it doesn't take place on your credit. It takes place on the credit of the legal entity that you control and own, but that you don't, that isn't you. Does that make sense?
Yeah.
Okay.
Question.
Yes, sir.
As far as the title company, though, isn't that what they do? They check the title, see if it's free and clear?
Title companies check the property, see if it's free and clear,
Yeah.
but all they're going to do is tell you it's not free and clear, and then insure your title for what is not found on the record. Now, that's not a fair statement, but in general, title companies will close transactions and issue title insurance to you with all kinds of problems and exceptions. They just disclose them, right? And then what they're insuring is what wasn't disclosed. It's an overgeneralization, but that's a reasonable understanding. Other questions? Yes, sir.
Can you just assume the existing survey of the property?
One of the things I was talking about, the weakness of the investors lobby. A few years ago, the surveyors really dropped the ball, and virtually every title company used to virtually require a new survey on every title insurance transaction. But the surveyors dropped the ball in the legislative session, and the rules were changed so that if there's an existing survey and the seller is willing to give an affidavit that says there haven't been any changes since the last survey I've got, and if the title company decides to accept that, and if your lender decides to accept that, you don't have to get a new survey. And so most of the time, if you're a savvy investor, one of the first questions you ought to ask your seller is, do you have an existing survey? Now, you ought to walk the property, because, I mean, he may lie and claim there haven't been any changes, and there may have been. And if there have been changes, you may end up with a problem because there's something on his property that's encroaching on his neighbor's property, etc. John, how are we doing on time?
Yeah, fine with it.
Okay, next question. Yes, sir.
Okay, I was led to believe that trust is a good way to anonymity and whatnot. What is the series LLC? Or?
Well, it really depends upon what you're talking about. Land trust could be a great way if you own property free and clear and you don't want people to know that you own it. The only problem is, guess where the deed into the trustee came from? Came from you. And if somebody's suing you, it's pretty easy for me as a lawyer not only to see where the title of property is now, but to see where it came from. And if I see a lot of properties going into trustees, I'm no fool. I can figure out that those trustees might be holding the property for your benefit. I use the example, if you've ever gone to Vegas and you've gone to one of the big shows, they have a tiger over here, and it's in a box. And they've got a box over here, and they show you that the box is empty. And they show you the tiger over here, and then the smoke goes up, and it's all black to begin with. The smoke goes up, all of a sudden, they open the box over here, and there's no tiger. The tiger's over here.